Good morning to all of you. Welcome to my interpretation of statutes class. Interpretation of statutes. So this is an introductory class where you are going to learn what is interpretation and what is the necessity to learn the interpretation of the statutes. This word interpretation of statutes, interpretation has been derived from the Latin word interprerari. Interprerari means to expound, to understand, to translate, right? So this is what is called interpretation. Secondly, what is a statute? Please remember, statute is the will of, statute is the order of the legislature conveyed in the shape of an act. Interpretation of statutes. Now you know what is an interpretation and what is a statute. So to interpret means to make you understand or to clear the ambiguity. Already I told you legal language or parlance is different from the ordinary language. Ubi remedium. How many ordinary people can understand this? Even how many lawyers can understand this? So definitely it's a confusing thing. Therefore, whenever certain words are very difficult, suppose court is a place where it is situated. What is it situate? Normally we pronounce as situated. So the word itself is confusing. So definitely you have to draw inference. You have to know. So when the words are not clear, when the words are ambiguous, and when the words combined, when the word placed in some place, they are giving a different meaning. What to do? You have to get them interpreted. You have to get their real meaning. So interpretation is, in other words, to know the legislative intent. So the true sense of the enactment by giving their words their literal and grammatical and ordinary meaning. So actually it is the court, particularly the High Court and Supreme Court. The main function of the High Court and Supreme Court is to interpret the law, to say that the provision is correct or not, whether there are any irregularities, right? So sometimes with the interpretation, may will become shall will become may. Now coming to the old jurisprudence. So Salman, he said that the essence of the law lies in the spirit, but not in the letter. So by letter, so you may beautifully frame the act, but if the spirit is not there, no use. Best example is 3 agrarian laws passed by very recently by the government of India. Of course, their intention is very clear. They said that the agriculturist can sell away his property from the field himself, but not agreeable. The spirit is good, the letter is good, but the spirit is not agreeable, not relished by the agrarians. They have come onto the roads, stayed on the roads for almost a year. Ultimately, they were taken back. So therefore, please remember Salman's definition. Salman says the essence of the law lies in the spirit and not in the letter, right? So you have to understand that the object of interpretation is to determine the intention, legislative intention or intention of the legislature conveyed expressly or impliedly through the language they use. And please remember, so interpretation is not a new subject. It is as old as the language, and it is always dynamic. అందుకని మీకు in the Jaimini principles or Mimamsa, తర్కము మీమాంస, all these things మీకు అడ్మినిస్ట్రేటర్ ఎక్కడ వస్తుంది. So all of them are examples of the so-called interpretation, explanation. So please remember. So in the process, several external aids and internal aids, they are also used. We are going to discuss them separately. So even what are the how to read the law, how to read the sentences. General, if you go through General Clauses Act, definitely you can understand the same, right? So to conclude, I want to tell you that interpretation means ascertaining the real meaning or ascertaining the real or significance of a particular word or object or thing, or ascertaining explanation of something which is not immediately clear or obvious when there is a so-called ambiguity, right? Interpretation has been an essential part right from the mischief rule case, Hayden's case, 1854. So definitely you have to read the topic of interpretation of statutes. No doubt, already I told you that it is the function of the High Court or Supreme Court. But as advocates, we are also supposed to know the interpretation. So you can interpret the law in your own way. Of course, it should be appreciated by the judge. Then only he will come to the logical conclusion. So please remember why there is a necessity to go through or to study the interpretation of the issues is, so normally when the language is ambiguous, when the language is not clear, or where two views are possible, or where the provision gives a different meaning which defeats the object of the statute. So definitely in such cases interpretation is very much necessary. So as far as the case laws are concerned, you have to remember whenever the introductory part comes, A.R. Antule versus R.S. Naik, 1984 case. So here Supreme Court clearly stated that when the words are clear, so this is the dispute regarding sending of Antule case to High Court or something, but ultimately since the words are clear that it has to be sent to the special court, it was sent. Likewise, Grasim Industries Limited versus Collector of Customs, Bombay, 2002. Here the main point is classification of goods. So whether rayon or artificial graphite, I think. Yeah, artificial graphite comes as a part of the heat exchanger to be used for the manufacturing of the so-called rayon or not. So here the point is machinery for making paperboard or not. It is definitely a commercial item, therefore tax can be levied. Very clear terms. So like this, so many examples will be there. This is only introductory part. I hope you understand, but it's a dry subject, but you have to write the examination. So for that, I have to tell you and you have to hear. With this, I am concluding. Thank you.